Hello, everyone, and welcome to Montgomery McCracken's webinar, Title IX Update, Reading Between the Lines. Before we get to introductions and the webinar, there are a few housekeeping items that I'd like to go over. First, we will try to set aside time at the end of the webinar to answer any questions that we may have. But we will also attempt to follow up regarding any questions that we do not have a chance to get to during the presentation itself. We've muted everyone for the duration of the webinar, but you can type a question in the chat box at any time, and we will get to it as we can. If you are logging in from a laptop or desktop, you can find the chat box at the top of your screen by simply clicking on Chat. If you are logging in using your cell phone, you will need to select Participants at the bottom of your screen. This will bring you to a new page where you will select Chat, and then you can type in your questions. We will also be sending copies of the slides around after our presentation today. Lastly, if you have any technical issues during the presentation, please contact events@mmwr.com. Now, without further ado, my name is Paul Apicella, and I will be presenting with John Myers today. I am a labor and employment attorney and a higher education attorney at Montgomery McCracken. And prior to starting my practice here, I also worked as a Title IX administrator at various colleges and universities around the country, some private institutions, and also I was a Title IX coordinator at a large public institution. John?
So I'm Johnny Myers. I've been in Montgomery McCracken about 20 years, and it was not my first job. I've been an employment lawyer, a criminal lawyer, a city lawyer, and a higher ed lawyer for about the last 15 years. In the Title IX area, I've been a trainer of panelists. I've been an investigator. I've actually sat as a hearing officer, and I've been an appellate officer. So I guess I've been around the block an awful lot. Part of my job is to try and coordinate the questions here, and we already have one that somebody can't hear anything. So we're going to try and get to you. If others are having this problem, let us know.
All right, thank you, John. So why are we here? Well, we've got three objectives today. As many of you are painfully aware by this point, the Department of Education has recently published new proposed regulations in the area of Title IX, primarily sexual misconduct, sexual harassment. And there are many, many fundamental changes that we are going to discuss. Again, many of these you're already aware of, but one of the things that we would like to do today is focus on learning what some of those changes are. However, that is not, I think, what we want to focus on primarily today. And we instead would like to focus much of our energy on what I think is a much more important question to all of you on a day-to-day basis, which is how do these changes fit in to how you run your programs on a day-to-day basis? And finally, to identify what is a possible path forward and perhaps some solutions and considerations to some of these key issues. One other thing I'd like to note before we begin is that we will not be covering all of the changes in the regulations in great detail. While the text of the regulations are very interesting and they are important to have read, the purpose of today's presentation is to talk about what is not in the regulations in the text. So we will be taking the approach of noting and highlighting many of the most important changes with the idea of focusing on how some of those changes and the textual provisions may impact how you administer your programs. Also, please note that the purpose of the presentation is not to induce fear or pile on to the already public criticism of the DOE. It's to get you thinking about a practical path forward in these difficult times. In sum, however, what the new regulations show us is that what you thought was familiar territory may actually be strange ground. Some of the basic parts of your Title IX process, such as what constitutes a Title IX report, what process do we use to administer our grievance process related to allegations of sexual misconduct? What about issues of confidentiality and complainants who request that their identity not be disclosed? What do we do with support measures, emergency measures, and other types of support resources that we provide to our students and our employees on a day-to-day basis? What about investigations now that these new regulations impose new requirements that significantly increase the degree of difficulty involved in conducting sexual misconduct investigations at many of our institutions. And then finally, perhaps most importantly, how does the hearing work now under the mandates of the new regulations? Even for those of you who have previously instituted a hearing process, you may find that the new regulations put you once again in unfamiliar territory. So what is new? Well, in short, one of the first issues that the Department of Education has implemented via the new regulations are changes to threshold standards that institutions are going to have to consider in processing issues of sexual misconduct. The DOE is now, for the first time, articulating a defined threshold for what constitutes a Title IX issue. These threshold definitions will significantly impact how reports of sexual misconduct may be processed at your institution. For example, the Department of Education has changed the standard of notice or knowledge that will give rise to an institution's obligation to address a report of sexual misconduct. Now, under the new regulations, actual knowledge is required, which means notice to an official who has authority to institute corrective measures, most likely the Title IX coordinator. There is no more respondeat superior or constructive notice. Furthermore, the mere ability or obligation to report an allegation of sexual misconduct or a report of sexual misconduct is not sufficient to trigger an institution's obligation to respond. Secondly, the department significantly changed the definition of sexual harassment for the purposes of determining what gives rise to the institution's obligation to respond. We won't go over this in detail, but we will just note that there are now three primary types of sexual harassment that the Department of Education has articulated, and that other types of misconduct that don't fall into these buckets or check these boxes may not constitute quote unquote Title IX misconduct. Finally, the Department of Education changed the context or scope of behavior that will give rise to the obligation to respond. Probably most significantly in this is now saying specifically that conduct that does not take place within the context of an institution's education program or activity is no longer considered Title IX misconduct.
So before I start, I want to remind everybody of this, which is something that we've talked a lot about here at Montgomery McCracken, and that is that these are not exclusive rules, which is to say, this is the DOE has not said this is your only obligation with respect to dealing with sexual harassment on campus, or limits your response to sexual harassment on campus. I think at a lot of schools there will be a lot of discussion about how much of your code and how much of your broader definitions, perhaps, of, say, sexual harassment you will continue to enforce, although not in the Title IX context, but as a disciplinary matter, to the extent that that can be separated out, which is just another complication that these things provide. So among the big changes are that the standard for the university is that it not be deliberately indifferent to Title IX concerns. And that's very different than conducting a reasonable approach, simply because to the lawyers who will litigate the confines of all of this, deliberate indifference is a much more difficult standard for somebody to meet with respect to your university. And in fact, these regulations provide a number of safe harbors where if you follow your own rules and regulations, you will not be considered by the department to be deliberately indifferent. Does that mean that a judge won't think you're deliberately indifferent? That's an open question. But with respect to issues with the department, you will not have a problem. It's also a very big change that now a formal signed complaint is required, except when there are multiple complainants. So the fact that somebody comes to talk to you as the Title IX coordinator doesn't mean you even have a right to start a process. You need a signed complaint under these rules. And if the complainant is not willing to sign the complaint, you cannot have a Title IX process. Again, what does that mean with respect to your disciplinary code in general? it's unclear and undecided, of course, at this point. The exception to that is where there are multiple complainants. Complainant 1, complainant 2, and complainant 3 come to you at different times and complain that Johnny Myers had sexually assaulted them. Even though each one of those people says, but I don't want to pursue it, you, as the institution, now have an obligation, certainly the right, to pursue this, although proving it will be difficult because of other measures it contained in the regulations. The supportive and emergency measures provisions here make it clear that you have the right to institute supportive and emergency measures immediately without much process, but, and the but is a big one, but they have to be even-handed. They can't be necessarily, they can't be punitive or viewed to be punitive in any way at all. If you go to the next slide 7, the changes to the procedure and procedures here is put them all up, is huge and really can't be covered completely in the forum that we have set up here. But let me just go through some of them. And the idea of going through these is for each of you to be asking the question, what does this change at our school? What will we have to change about the way we do things? We've already talked about the fact that there has to be a formal complaint signed by the complainant. If it's multiple complainants, it's the Title IX coordinator who would undertake to issue that complaint and who has the obligation to file that complaint. There's lots of language in these regulations about the need for an objective evaluation, to have people trained and to have them be conflict-free. I doubt whether anybody's on the phone saying, well, we don't want to have to train anybody in this, and we don't want to have to care about conflicts of interest. That's kind of embedded in the process that most places are already doing. When you get to the question of notice to the respondent in these cases, things are much different. First of all, these regulations say that notice has to be given, quote, upon receipt, quote. Although there is a vetting process that you must complete before giving that notice, it basically means you have a short time frame before investigating anything in which you have to put together a notice and give it to the respondent. And that notice has to be quite specific. It has to state the specific conduct that is complained of. It has to state the section or sections of your conduct code that are contended to be violated. It has to identify the parties relevant to the complaint. It has to give time and place. Very, very specific. So you give the notice with all that in it to the respondent, and then you are obligated to give the respondent time before you begin your investigation. That investigation is something that you must, in the language of these regulations, undertake. But there must be sufficient advance notice, in the words of the regulation, to the respondent that an investigation is about to be undertaken. The respondent has open access to all of the evidence, whether you are using it or not, as does the complainant. You can't ask people to keep it confidential or have any sort of gag order because the department believes that limits or could limit the ability of a respondent to gather evidence. Both parties have an equal right to be present at any stage. And I think really important in this process is that there's no longer a limit on who the advisor is with respect to a student, respondent, or a complainant, although there remains the ability up until the hearing to limit the role or the conduct of the advisor in the process. So it very well may be that although now it appears that outside lawyers will be permitted at the earlier stages of the process to be present, it may very well be okay for you to have your own rules providing for the potted plant approach to the lawyers, at least until there's a hearing. At the point at which an investigation is concluded, you have to tell the parties that you have concluded the investigation. You have to make available to them the evidence. And before any report is issued, you have to give the respondent at least 10 days to respond to what the investigation has revealed to be. So there's a bit of a time delay there. And that's before issuing the report, which will either, which in most cases, I think, will lead to a hearing. Okay? Unlike under the old regimes, informal resolution is definitely permitted. It's a may, not a shall. And you need written consent in order to do an informal resolution process. How that's handled is likely to be the subject of tremendous concern, I believe, in the comment period. Oh, the single investigator model is out. As far as I can tell, it's completely out because a live hearing following the report is required. A live hearing at which all evidence is open to both sides. A live hearing at which an aligned advisor, aligned is the word of the regulation, is permissible for either party. And if there is no aligned advisor, the school is said to give them one. I think that was a pretty hard task to find the volunteers to do that under the old regime. Since there is now this advisor examination, or what I call lawyer cross-examination at this hearing, I think the job of finding an aligned advisor for the complainants will be very, very hard. Unlike in court, where a judge can just say, that objection is sustained, you can't pursue this line of questioning, and go on. These rules require that should a hearing officer do that, the hearing officer must explain then and there what the basis for the objection is. I think for a lot of schools, what that will mean is that a very highly trained person will have to be the hearing officer, and I think many of you will likely make a decision that a lawyer will have to be the hearing officer because what you're looking at under these regulations is a two-lawyer hearing in many cases, and it will be very, very difficult to control that. And there's also a provision then that talks about providing physical separation, as though it's no big deal to provide the technology for multiple video screens in separate rooms and that sort of thing. I think that will be a big burden on some schools, particularly smaller schools, maybe technically less advanced schools. It's another pressure point for the burden with respect to the burden and expense of these hearings. And then the last thing is with respect to post-hearing matters, there has to be an equal right of appeal. And those are the high points. Paul?
Thank you, Johnny. And so the view from above, sort of what does it all mean? Repeatedly in the draft regulations, the Department of Education states that one of their main objectives in drafting the new regulations is to create clarity and simplicity of process and clear thresholds and clear decision-making steps for institutions that translates into transparency for the individuals that are involved in their process. And so when you look at a graphic representation of what that looks like, it seems relatively straightforward. You get a report, you consider your threshold issues, then that will drive what your response options or obligations are. Could be informal resolution only, could be supportive or emergency measures only. You could have a formal complaint. You could have a written formal complaint, or the Title IX coordinator may be mandated to institute a written complaint based on the fact that they have multiple reports against the same respondent. Either way, that's going to result in a formal investigation. You have clear investigative procedures that are laid out in the draft regulations. You have a 10-day delay until the report with a clear procedure about how that report has to be distributed and drafted. Then you have 10 more days until the hearing process begins, and then the appeal process, whatever appeal process you have laid out in your procedures.
So we have a question about whether the formal complaint means a formal complaint to the police or the university. Clearly, it doesn't mean to the police. Clearly, you don't. There's no requirement under Title IX that a complainant of a sexual assault be required to report to the police. He or she has the right to handle this completely within the university and ask the university to handle it as a Title IX.
I will say, however, that the complaint, even if it's a written complaint, can't be just submitted to anybody at a university, just any responsible employee. That complaint must be submitted to the Title IX coordinator. And so we see again this, what looks like a relatively straightforward procedural process as laid out in the regulations. However, when we start considering all of the different concepts, changes, definitions, the burden of implementing these procedural steps in, we see that this actually becomes a very hectic and very difficult picture to manage. And these are issues, some of which we've highlighted here, there are others in the regulations, that you as administrators or legal counsel or investigators will be asked to manage as they occur on an ongoing basis once the regulations go into effect. And so let's talk about some examples that highlight some of those specific issues.
So before we get to the examples, I think it's probably worth pointing this out. Paul and I have done, at this point, a number of presentations, probably 6 between us, on various aspects of Title IX. So we're kind of pretty far along this road. The idea, the first part of this is to sort of lay out those, the important changes, which is really not much more than an encouragement for you, for each of you, to become as familiar as you can and have time and capacity for the changes that are being proposed and what impact that would have on your process, kind of a side-by-side that has to be done. But we thought that really, and for the next half hour, we thought the best way to sort of have you thinking about this is to work through some examples that include all these changes and give you an idea of what situations will look like under this new regime should the regulations become final as proposed.
Thanks, Johnny. And so the first couple of examples that we're going to talk through highlight what I was mentioning before about the importance of these threshold determinations. What is the actual operational significance of the changes in the definitions that the Department of Education has imposed, as well as the requirement that the schools or the institution's response be driven by whether or not the conduct that's been reported meets those threshold definitions. And so the first example we're going to put on the screen for you, and I'll read it to you and then we'll talk through some of the issues. Emily contacts you in your capacity as the Title IX coordinator of College U and reports being sexually assaulted by Charlie while at a party at the Hockey House the weekend before. The Hockey House is located 6 blocks from College U's campus and is a private residence occupied by members of College U's ice hockey club. is frequently the scene of raucous weekend parties. Charlie is a member of the hockey club and lives in Hockey House. Now, this may seem like an example that sounds awfully familiar to some of you, or at least doesn't sound like it's too outlandish. Under the prior regulations, it was pretty clear that this is an issue that you as a Title IX coordinator would have addressed through the institution's Title IX or sexual misconduct procedures. However, under the new regulations, the determination is not nearly as cut and dry. And so the first thing that we'd like to look at is, does the report meet or check some of the boxes that we talked about? Do we have actual notice here? I think the answer here is clearly yes, because the complainant reached out to you in your capacity as the Title IX coordinator. Does the conduct constitute, quote unquote, sexual harassment? I didn't get much into the definition of sexual harassment at the beginning. I mentioned that there are three different buckets, sort of, that it can fit in. Those three buckets are essentially quid pro quo. So an employee of the university conditions provision of aid or a benefit upon a complainant's participation in unwelcome sexual conduct. The second would be hostile environment type sexual harassment. And then the third is sexual assault, as that is defined under the Clery regulations, which incorporates in turn the FBI's definition of rape, incest, or statutory rape. And so I think here there are some other details that we could have that could make us feel a little bit more comfortable about the determination about sexual harassment. But because the report was of a sexual assault, I think it's safe to assume then that this meets the sexual harassment prong. Less clear, perhaps, is whether or not the sexual assault took place within the context of the institution's educational program or activity. And so we'll highlight some of the key facts here. The incident takes place in an off-campus private residence, but it does involve the hockey club, which is affiliated with the university. We may need to know more information in order to make a final determination about whether or not this meets the standard. For example, what exactly is the nature of the hockey club's involvement with College U, and whether the raucous parties are part of a university-sponsored, promoted, or endorsed event. But all things considered, with what we know now, this likely is not what I would consider a program or activity, meaning that College U's new Title IX obligations are probably not triggered in this case. Our next example, however, shows...
Before you go to the next example, there's the additional complication in this example that this is not on college property and it's outside the geographic confines of the university, which is, again, a factor that makes it less likely that it would be mandated under Title IX that you pursue discipline for this activity. Again, the reminder, that is not the same as saying that you as a university shouldn't do something about this situation, because there's nothing in the Title IX, proposed Title IX regs that says you can't do anything.
Thank you, Johnny. And those contrasts are highlighted with our following example. And so here in this example, Sean contacts you in your capacity as the Title IX coordinator at College U and reports having been sexually assaulted by multiple members of the Psi 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 fraternity during a $10 all-you-can-drink keg party at the fraternity's on-campus house 1 month ago. According to Sean, the party was organized as part of College U's annual Brothers and Sisters Drive, which is a week-long charity fundraising drive to benefit College U's Library Renovations Fund. Well, College U encourages each affiliated fraternity and sorority to come up with creative ways to raise funds and publishes annual rankings based upon the amount of money raised at related events. The university does not supervise or control the events themselves. Sean attends a different university across town, but demands that you/College U take immediate action to discipline the three named assailants. And so let's talk through this again. Is College U's Title IX obligation triggered by the incident that Sean reports? First, again, do we have actual notice? Again, I think that this is a pretty easy yes, because Sean has contacted you in your capacity as the Title IX coordinator. Again, sexual harassment, same thing. I think we can assume that that's the case because Sean reported a sexual assault. What about the question about an educational program or activity? Here, I think the question or the answer is more clear than in the prior example where we had an off-campus residence with a club that seemed to be more loosely affiliated or endorsed by the university and an event that was not clearly promoted, sponsored, or endorsed by the university. In this case, it's an on-campus fraternity house. Many fraternities are much more closely aligned with the university, and this takes place as part of a fundraising drive, a week-long event that is sponsored and promoted by the university. And so in that respect, I think that we can say that this does take place within the context of an educational program or activity. But the commentary to the regulations actually introduces another very interesting distinction that you may find of very serious import in your individual programs. And that is, what about access? Was Sean denied access to an educational program or activity at College U? The answer here, I think, is no. Because Sean is not a student of College U, and we have no facts suggesting that Sean intends to become a student or to otherwise access the educational programs or activities of College U. Now, to me, as a formal Title IX coordinator, administrator, and an investigator, that seems to be a very stark departure from what we have learned about Title IX over the past 6 or 7 years. However, again, in the commentary, the Department of Education addresses directly a very similar circumstance to this example, in which a student from another university was sexually assaulted on campus by 3 members of the university and was subsequently filed a lawsuit and had her lawsuit kicked out of court because the court determined that she was not actually denied access to an educational program or activity, and therefore her claim did not fall under Title IX. And so now the practical implication of that is, again, if you think about this, this is going to be a big deal for your program. United Educators recently published a statistic that estimated that something like 41% of sexual assaults occur off campus. And so this is going to come up, these type of situations. Johnny mentioned the fact that while this may not be a quote unquote Title IX incident, the institution still has the option of addressing that conduct through its normal conduct procedures. But when I think about what that means, what that procedural decision and the difference between those two procedural routes mean, it really starts to highlight what I think are some of the really big problems with some of the draft regulations. So, for example, if College U decides that they are going to address this allegation of misconduct as a student conduct matter, they have to make a decision about what that student conduct process is going to look like. You may now have 3 individuals who have been named in a sexual assault who are being processed through a student conduct process that has significantly less protection than the Title IX process may have for the same conduct. Now, College U could theoretically choose to process them through a process that looks very similar to their Title IX process, or they could choose a middle ground. However, the issue I'd like to highlight for you, and what I'm sure you're already thinking about as I'm talking through this, is that's going to create many of its own problems and is likely going to result in a pretty vigorous and pretty quick challenge to College U's decision.
The administrative complication of running 2 parallel but really different systems with different protections, I think will be more than most people can handle. So I think it's very unlikely that would be a decision that anybody would make. We have a comment that has come in, which is, wow. And so I puzzled for a minute as to whether to say, is this a comment on the changes in these Title IX regulations that are proposed? No, probably not. I'm going to take the other, another interpretation here, which is that Paul and I are doing a fabulous job and not too many people have hung up so far. Keep going.
Thanks, John. Our next example here also highlights another difficulty with some procedural decisions that you as a Title IX coordinator, as an investigator, or as an administrator or legal counsel at a college or university may be forced to make that may cause problems with your institutional philosophy, your community standards, or your personal or organizational values. And that relates to the scenario that involves multiple allegations against the same respondent. And so in this example, we have Jasmine, who comes to the Title IX office to report that she was sexually assaulted by Terry in her room in the on-campus residence hall over the weekend. You listen empathetically as Jasmine describes her experience in great detail, and then you carefully inform Jasmine of her options and the university's Title IX process. Jasmine begins panicking when she hears that she would have to answer detailed questions by Terry's advisor at a hearing, and insists that you not even talk to Terry about her report. Less than 1 week later, Marta emails you in your role as a Title IX coordinator to report that she too had been sexually assaulted by Terry after watching a movie together in the residence hall the night before. Marta refuses to even come to your office to talk in greater detail, but says that she wanted to report the incident in case it happened to anyone else. Now, again, this is a situation that you out there doing the work on a daily basis probably have heard before or heard something similar. And the way that you would handle it under the prior regulations is likely going to be very, very different. Under the prior regulations, you were likely to very heavily weigh Jasmine's request for confidentiality, as well as weigh Martha's hesitance to come in and talk to you or give you more detail. You may address it in some manner, but depending on the details that you learn, you may decide that this is not something that you may vigorously pursue, or that you may pursue it in a way that maintains the privacy and confidentiality of the individuals involved. Well, under the new regulations, I think you're likely going to have to reach a different result. Again, here we have a report that clearly meets the threshold. We do not have a formal complaint, but we do have multiple complaints against the same respondent. Under the new regulations, you as the Title IX coordinator will be obligated to institute a formal complaint on behalf of the two complainants. Now, that in and of itself, to me, signals a big change, right? We are starting to worry about issues of confidentiality. The regs themselves, the department says that part of the reasons for the changes is to provide transparency and give complainants significantly more control over whether things are investigated or not. But you now have Jasmine, who indicated that she under no circumstances wanted Terry to even know about her report or to engage in any sort of university process. You now have to institute a formal process. And that implicates many of the notice requirements that Johnny talked about earlier, including the identities of the parties involved, the specific information or the allegations, the dates, the places, the locations, all of those things that were disclosed to you by Jasmine, even though she disclosed them to you in the context of not understanding yet your process, only seeking support, and then specifically saying that she did not want that information disclosed. Again, as a former Title IX coordinator and a former investigator, this causes me a lot of anguish just thinking about it. It is going to change the way that you relate to complainants who come into your office. It is very likely to chill reporting on campus in a very big way. And you may very well find that it puts you as an individual, your office as an office, and then your institution as an organization in some very difficult spots. It also, for me, suggests a significant risk that even if you do institute a formal process or institute a formal complaint as required by the regulations, you are now putting the respondent into a formal process, knowing at the outset that you are very likely not going to be able to find enough information to find them responsible for Title IX misconduct, right? You already know that you are very unlikely to have two complainants who are going to even talk to you at all. And so I question the purpose of instituting a formal complaint in this instance. There may be other instances involving formal complaints that it makes more sense. However, again, I think that this is a pretty common occurrence, and it's a dynamic that you may have to consider how you're going to manage.
And let me just add that this requirement that you start a process is nonetheless going to have you sitting there or with alone or with other people and saying, what about the mental and physical health of the two women involved in this example? And what would a complaint and the outing of them, so to speak, do to them? And it may very well be that this, what Paul euphemistically calls the difficult spot, is really deciding in some cases, facts of which will be wildly variable, that the protection of the complainants is more important than the prospect of facing a Title IX action by the department for not doing this. The respondent, of course, will not be the instigator of a Title IX action for not doing this. The complainants won't be because they specifically asked. The context in which this comes up is on the third assault, when somebody finds out there were two prior assaults and nobody did anything. How you make that judgment will depend mightily on the facts of each case. It's really easy to sit in Washington and write regulations. It's really easy for lawyers like us to say, oh, no, you have to follow the regulations. Your seats are much more uncomfortable than ours.
Agreed. And so the next topic or the next example we're going to cover is another area of this work that, again, I think is extremely important and, in my experience, provided much of the volume for the work that I did on a daily basis. And that was the provision of supportive measures, or as some are now referred to, they used to be called interim measures. Now the new regulations are called emergency measures. We're going to have to rethink that whole process and what the dynamic looks like. And again, this is extremely important in a variety of ways, including how it interacts with the investigative process and outside of the investigative context. Again, how it affects your community, how it affects individuals who report incidents and then feel like there are significant barriers to them receiving the kinds of institutional support that will allow them to continue their education without interruption. All right. And that, again, involves the provision of supportive and or emergency measures. So this example involves Greg contacting his anthropology professor to let him know that he failed to sit for his midterm the week prior because he felt uncomfortable seeing his ex-girlfriend in the classroom after she took advantage of him while he was sleeping in his room in the residence hall. Greg tells his professor that he needs to pass the class in order to graduate and asks if he can take a makeup exam in order to do that. The professor calls you to pass along the report, and you invite Greg into your office to talk. Greg tells you during your meeting that he doesn't think he can, quote, go back in there after what she did, but refuses to provide more details. Greg demands that you move his ex-girlfriend to a different section so that he can finish the semester and graduate. So what does this mean for us when considering what our next steps are going to be? How do we evaluate Greg's request? What are the things that we're thinking about? And what is the likely result of that decision-making process? Under the prior regulations, again, I think that you as an institution would have been provided significantly more flexibility in how you handle this situation. And I think that the result in this instance under the new regulations may very well be very much different than what it would have been under your prior approach. All right, so what options do you have? And I'll note for a minute that we are going to ignore, for the purposes of this example, many of the threshold issues, although I do think it's something that you will have to consider, right? We're going to assume that they meet the threshold. Greg implies some sort of inappropriate touching, which could meet the definition of fondling or groping under sexual assault, okay? But one of the things that we did not mention in great detail about supportive measures and emergency measures are that when providing emergency measures, which I think is what Greg is asking for here, a removal from class, perhaps against the respondent's will, is that an institution can undertake emergency measures, but can do so only if they have met 3 specific conditions. And that is that they have conducted an individualized assessment involving the respondent and the facts that are known, and that they have concluded that the respondent represents an immediate threat to the health or safety. Okay, and so if the institution has or is able to do that, they may be able to implement an emergency measure. So how do we know this is an emergency measure instead of a supportive measure? Well, I think that while it's not stated in the regulations, if you read the actual commentary, I think it becomes clear that they would consider a forced removal from an educational opportunity to be an emergency measure, right? The regulations list supportive measures. They include things like counseling, free counseling. They do not include things that are done against the respondent's will, such as, again, forced removal from a class or removal from a residence hall. And so I think this is an emergency measure, and you're going to have to conduct that individualized assessment and determine that the respondent represents an immediate threat. So what's the problem here? Well, I think there are a couple. I think that you don't have enough information in this instance necessarily to conduct an individualized assessment. While Greg has given you enough information to suggest that this is a Title IX report, in quotes again, he has not given you enough information to suggest that the respondent, or that even he considers the respondent, to represent an immediate threat to his health or safety. He says that he feels uncomfortable, right, and that she took advantage of him. He doesn't state any facts that imply use of violence, a weapon, again, multiple instances of misconduct. He simply says that he's uncomfortable. Again, based upon the text and the tenor of the commentary, I think you're likely not going to be able to remove the ex-girlfriend from the class unless it's something that she wants to do. And so again, the practical implications of what, in my experience, again, is a very typical situation and a typical request that you likely are going to receive is that you now have to consider what else you can do, what else you're going to do with respect to Greg. Greg has told you that he needs the class to graduate. He's unable to move to another section, but he also feels like he can't go back to the class. Unfortunately, you may find that in an instance like this, your hands may be tied. And again, you'll have to think as an institution, as a group, about what that means for your institutional values and how you're going to address that situation and support Greg moving forward.
Before you start the last little bit, let me remind everybody that we may have time for a few questions at the end. And if you have a question you'd like us to comment on or give some reference to, use your chat room box and fire away.
Thanks, Johnny. Okay. So this last example that we'll cover, I call at the crossroad, crossing quotes because I'm big on witty puns. This involves the institution or the situation of a hearing. And what are the administrative problems involved with a hearing? Again, thinking back to how these may actually come up and be applied on the ground in the moment. Kara files a formal complaint to her college's Title IX coordinator and alleges that she was subject to a pattern of physical and emotional abuse by her ex-boyfriend, Tom. Kara and Tom are student athletes, and Kara alleges that Tom exhibited instances of abusive behavior at various locations on campus and during off-campus athletic meets. Kara engages in the investigative process without an advisor, but Tom retains an attorney as his advisor and declines to meet with the investigator until witness interviews have been conducted. And even then, only after being given an opportunity to review all information in the investigative file. As the hearing approaches, Kara is provided with a support advisor picked from a volunteer pool. At the hearing, Tom's advisor cross-examines every witness in detail, including exhaustive follow-up. Kara's advisor also cross-examines Tom, but she is not an attorney and is not as skilled at challenging Tom's credibility. Tom's advisor cross-examines Kara for 1 hour before the hearing is adjourned for the day, reviewing the particulars of each incident of alleged abuse, and requests that he be given an opportunity to resume the cross-examination in a subsequent hearing session. Okay, so again, putting on my operational hat here, we've got a variety of issues and problems that come up in this example that, again, are very likely, almost certain to come up in hearings that you yourselves may find yourself administering. All right? And so what do you do here? All right? One of the questions that I think this example presents is, what is a sufficient opportunity to cross-examine? The new regulations require that you give each party sufficient opportunity to cross-examine the opposing party as well as all witnesses, including asking all relevant questions and related follow-up. All right? But at what point does that become so burdensome that it makes the process unmanageable? We have a situation here where a hearing has gone on all day. Tom's advisor has been allowed to question all of the witnesses, including follow-up. There's no indication that he's been excessively rude or combative. However, the very fact that this has gone on all day is a problem in and of itself. And so you're going to have to think about where to draw that line. I don't know that there's an answer. There certainly isn't one in the text of the regulations, but it's going to be a problem that comes up. Who referees these exchanges and by what standard? Again, the regulations say they should be given an opportunity to conduct a thorough cross-examination, including all relevant questions and related follow-up. But as many of us know who've ever had the pleasure of interacting with an attorney, relevant questions and thorough follow-up can be a very flexible concept. And so, I think that this is going to come up. What do you do about rudeness? What do you do about aggressive questioning? There's nothing in the regulations that deals with that. And as an institution, to the extent that you have administrators or faculty members, non-attorneys, non-judges refereeing these hearings, you're likely going to have someone who has received 1 day of training, 2 days of training, some other form of minimal training, now attempting to rein in a trained attorney who is acting on behalf or representing his client in cross-examination.
And one of whose jobs is to make you cut him off. So he has another piece of ammunition with which to appeal to the courts to say that the process was unfair.
Exactly. And I think that, again, we're not to beat a dead horse, but as we sort of talk through this and as you start to think about what that's actually going to look like, as opposed to just what the regulation says, I think it becomes apparent to you that this is going to be a significant problem.
And really one of the reasons why you really need to think long and hard about who is going to be the hearing officer or who is going to be there to support the hearing officer in these sorts of decisions. I could imagine at least two possibilities, one of which is, to have a lawyer or a retired judge conduct the hearings. The other is to have somebody, to the extent you have the resources for this, to have somebody from your general counsel's office or your outside lawyer there to advise the hearing officer about when to declare enough is enough.
Exactly. All great points. What about the refusal to be crossed? Very quickly, again, the regulations and the commentary make clear that in the instance that a party or a witness refuses to be subject to cross-examination at the hearing, the fact finder is to disregard any statements and perhaps information overall that that person has presented during the process. And so what if, for example, Kara says, you know what, I gave you an hour, I went through this all day, I'm not coming back for another hearing date that we don't even have scheduled, I've had enough. What are you going to do? That effectively could be the end of the process. And now you just devoted all that time and resources, perhaps money, into administering the process, and now you come to a point where there's a non-starter right at the end. The same thing relates to witnesses. As an institution, you likely don't have the opportunity or the power to compel witnesses to appear at these hearings. What if key witnesses just don't show up or don't want to be cross-examined at a hearing? It likely, again, is going to become a real roadblock in your adjudication process. Other issues. What about advisors? Kara's advisor is not an attorney. The regulations state that if an individual does not have their own support advisor, the institution has to provide one that is aligned with that person. And so in this example, I used the complainant who has an advisor who's not an attorney. What's the standard? How competent do advisors need to be in relation to the other party's advisor? What is that going to look like, and where are you going to find these individuals? Are you going to retain or pay outside people, outside attorneys to function as advisors? Furthermore, where are you going to find advisors for respondents? Again, one of the big problems that I encountered as a Title IX administrator was finding individuals who would volunteer on an ongoing basis to be support advisors for respondents, and that's when the process didn't involve cross-examination. I'm not sure where you're going to find those individuals now, again, without retaining outside experts. And then last, and we'll sort of gloss over this in the interest of time, there are issues about this example that I think highlight some of the important points in the investigative procedure. This is a complicated investigation about conduct that has been going on for a prolonged period of time in multiple locations involving multiple witnesses and involves allegations of what seems like some pretty significant physical violence. This is a highly charged situation, and yet when you think about the burden of notice, ongoing notice, providing updated, thorough notice to the respondent every time somebody mentions a new incident, providing the same notice to the complainant, for example, providing availability of information. The fact that the respondent in this instance has waited and refused to engage in the investigative process essentially until you've reached the end of what you could do with the complainant and her witnesses. These things are going to come up. If I'm a respondent, somebody's going to have to explain a good reason for me as to why I should engage in the investigative process before you've reached the end. Because when I have a right to view all information in the investigative file, I have every incentive to wait until there's information to review. And furthermore, I've retained an attorney as an advisor who's going to assist me in reviewing that and driving my response. All right? And so, again, in the interest of time, we'll go for a couple more minutes here. But there are other big issues that come up in these regulations. We've highlighted some of what I think are the major ones. This is, again, just the beginning of what your thought process should be and your problem-solving process. There are others. Johnny talked about the informal resolution process. Just because informal resolution processes are available in sexual assault cases now, does that mean that you should be conducting sexual assault informal resolution processes, mediations, for example? If so, who's going to do that? Because you may find that you need someone who is significantly more experienced or more savvy in these situations than the individuals that you had prior. And that segues into my next point, which is you may have to rethink training. You definitely have to rethink your training materials as they relate to your coordinator, your investigators, and your adjudicators, because the new regulations have made clear that training materials must be unbiased. They cannot be slanted. They cannot rely on sex stereotypes. And so for those of you out there, which I think is almost everyone, whose training materials included, for example, the neurobiological effects of trauma as they relate to the complainant in relaying their memory of an assault, you are now also going to have to think about including similarly focused information about the effects of stress and the inherent effects on memory of being accused of sexual misconduct on, for an example, an 18-year-old freshman male, again, for example, who's now been called into an office to be questioned by an attorney investigator. Okay? They're going to have to talk about those things. You may have to consider whether you include in your trainings, for example, that statistic that 2% of reports of sexual assault are false reports. And there are various reasons for that, but I think courts have started picking on that statistic in particular, and I think that's going to continue. And then last of all, another trap here, another thing that I think is not necessarily apparent on the face are the administrative burdens that are imposed by the new regulations. The paperwork burdens for now, for example, for the first time, the department has made explicit the fact that an institution must retain for 3 years, not just their investigative file, but also all notes related to the process or processing report and assessing or administering supportive or emergency measures. And you can expect that that's going to come up in an OCR review. You can expect that it's going to come up in litigation matters where individuals are challenging, for example, whether or not they represented an immediate threat to someone's health and safety, justifying their removal from an educational opportunity. So that begs the last question that we're going to address here before we wrap up for the day, which is where do we go from here, right? What are the umbrella effects? I think there's going to be an overall chilling effect on reporting on your campuses. Again, a hesitation to engage in the process. As the effects of reporting become clear to the people who experience these incidents, they're going to be less likely to come forward. The degree of difficulty on everything that you do is going to be ratcheted up in providing support, investigations, adjudications, considering reports, even convincing individuals internal to your institution to report incidents is going to become more difficult. And you can expect, despite the fact that the regulations say that they are making things clear, you can expect significant uncertainty on an ongoing basis. You can expect adversity in the forms of respondents and complainants challenging your process, and an increase in litigation as individuals no longer feel that they can go the administrative route through the Department of Education or get their problems addressed through lower barriers involved in your process. So again, where do we go from here? I think it's very important that you all take, if there's one thing that you take away from our presentation today, it's start thinking about these things and participate in the notice and comment period. It's likely I say our because I feel involved in this issue as well from your perspective. It's our last opportunity to get a say in this process and to convince the Department of Education to change course on any of these issues that are important to us as an institution. The second thing I'll say is I will implore you to start looking in the mirror now. Get a working group together, put your heads together and start talking through some of these issues on a daily basis. What does this mean for us? What's it going to look like, right? What kind of institutional, community, or cultural issues is this going to raise? How does this implicate our policy and procedure? How are we going to make changes? Institutional policy changes take a long time. And so what's that going to look like for us? How are we going to go about it?
And it looks like those changes could very well be required as of the fall semester next year, 2019.
It's possible, depending on the grace period that's offered, but they are coming. And so you're also going to want to start reviewing your websites and your printed materials, because you are going to have to be providing information in a new way. You're going to have to be providing different information, and also you're going to want to provide that information in a different way in order to account for, again, how individuals may be discouraged or encouraged from reporting or engaging in your process. Start revising your training materials now. Again, these are processes that take a long time. Same thing with your administrative systems. These are mandatory administrative requirements now related to paperwork, related to complaint logging, all of these things, that if you don't have the resources in place to handle it and you sort of were just hoping that you never got put on the spot, you can count on the clock running out on you once these regulations go into place. And what all of these things come together as, develop a plan. Again, these changes are going to take time. They're not going to be easy. They are going to require the expenditure of political capital and actual money in order to implement, and that's something that you are going to want to get ahead of to the extent that you can. Lastly, consider your resource issues. Again, we talked about investigators, we talked about advisors, we talked about adjudicators. As complaint volume goes down and the formal process volume goes down, because people are less likely to report or engage in the process, some institutions are going to have to consider whether or not it is worth it for them to retain or employ full-time individuals who are investigators or adjudicators, for example, right? You're going to have to strongly consider whether it makes sense, even if so, if you want to move to external individuals because, again, of the degree of difficulty that's required here. Where are you going to find advisors? Who are they going to be? You may, again, strongly consider retaining attorneys or a couple of attorneys on an ongoing basis to serve as advisors in these processes so that you can call on them when you need them, because the reasonably prompt timeframes that are imposed now in the regulations, it says administrative burden is not a good reason for delay, right? It's not sufficient reason for delay. So you can't say we didn't have an investigator on deck, or we had too many complaints, or the process took us too long because it's too burdensome. You're not going to be able to say that anymore. You're also going to have to consider how and where supportive or emergency measures are provided at your institution. The regulations now say the Title IX coordinator has to be responsible for administering that process. And so for those institutions that have that outsourced to another office that is outside of the Title IX coordinator's office, they're going to have to think again about bringing that back into the Title IX coordinator's office, not outsourcing it to external organizations or other offices within the institution. So these are all really big questions. And so that brings me to my last point, which is you should ask for help before you need it. So if the issues that we discussed today seem confusing or overwhelming, I understand that. They were overwhelming for me to think about and consider and to reduce into a roughly 1-hour webinar for you to review. And so you're going to want to think about these as well. And I would, again, very strongly encourage you to engage and help others who can look at this from a different perspective, either inside or outside your institution, so that you are ready when this comes. Don't get caught behind the curve. And that's it. Again, I thank you. Johnny thanks you as well very much for your participation today. I apologize for any technical issues. We will be distributing slides. We'll also be hanging around here for a couple minutes to the extent that we can to answer any questions that people may have that they didn't want to ask during the main portion of the presentation. You should also feel comfortable to submit questions in writing after the fact, or to reach out to either Johnny or myself afterwards so that we can be in touch and talk through any concerns or issues that you might have. Thank you very much.